Hello, I'm attorney Will Inman. What is a legal retainer in a workers' compensation claim or in a personal injury claim? Well, in Maryland, a lawyer must have a written retainer signed by the client before they are allowed to represent the client if the matter involves what's known as a contingent fee. A contingent fee is an agreement that the lawyer does not earn a fee unless he gets money for the client. This applies in practically all personal injury and workers' compensation cases. So, since it applies to those cases pretty much 100% of the time, in workers' compensation and personal injury cases, a lawyer must have a retainer that you have signed. What does the retainer have to say? It has to set forth the case for which the representation is being agreed to. So in other words, a car accident on February 3rd, 2023 in Montgomery County. It has to set forth the fee so that you understand exactly the fee that will be charged. It has to set forth who is responsible for costs. Usually it's the client that's responsible for costs. It should set forth what happens if you lose your case. Will you still be responsible for the costs or not? And finally, it should tell you what happens to your file after the case is done. For example, at my firm, we hold our clients' files for 5 years after a case is done on average. And after that period of time, we reserve the right to have the file destroyed because we can't keep files forever. So when you get a retainer from an attorney, read it through. Make sure you understand every sentence. If there's anything you don't understand, ask the lawyer. The lawyer should explain it to you to your satisfaction. If you have any questions about retainers in general or the hiring of a lawyer, call me at 301-315-9400.